them down to be able to recite them to you, although they're in the record. But I do think the premise of the question is wrong, this idea that the change to in-person dispensing would necessarily increase the risk of those events. That was not reflected in the data that FDA consulted, and I would point you to JA 383 to 384 in particular, where FDA explained that even in person, you're not necessarily getting an ultrasound. That's never been required. And so the relevant question might be, is your provider going to ask you a series of screening questions, like when was your last menstrual period, in person or via telemedicine? And there's no evident reason why that difference would actually lead to different safety outcomes.
So there was not even I thought that there was a small percentage increase in the tracking. I'm wrong about that, which I may well be. You know the JA way better than I do.
Yeah, so I think that with respect to the ER visits, there was some evidence that there were increased ER visits, although as I explained to Justice Alito, that wasn't actually correlated with an increase in serious adverse events. You know, I don't want to represent all of the different findings of the different studies because they varied a little bit, but FDA's ultimate conclusion was that mifepristone could safely be dispensed without in-person visits. It had voluminous evidence, I think, to support that conclusion in 2021, and there's been no contrary evidence that's been introduced.
So there was no requirement of either an ultrasound or detecting a fetal heartbeat or anything like that, even before the doctor could just go based on the woman's recounting when her last menstrual period was.
That's right, and that dates all the way back to the initial approval of this drug in 2000. It has never been a required condition of use to have an ultrasound. FDA has always left that up to medical judgment. Now, it is of course necessary for providers to be able to diagnose ectopic pregnancy and to date gestational age. That remains true under the REMS now. Prescribers still have to have that capability, and they have to deploy whatever mechanisms they believe would accurately allow them to identify contraindications for use of mifepristone. But it's wrong to suggest that if the court reverses 2021 changes, then every woman's going to get an ultrasound. That's never been the state of play in how this drug has been administered.
How, even under the pre-2021 REMS, was it possible to detect an ectopic pregnancy without an ultrasound unless the woman was presenting with pain?
So there's a set of screening questions that are often deployed. You can ask things like, do you have unilateral pelvic pain? Did you become pregnant while you had an IUD in or after a tubal ligation? Are you experiencing unusual bleeding? You can ask whether the woman has had a prior ectopic pregnancy. And if the woman has those kinds of risk factors, then imaging may be necessary. But that remains true under the 2021 REMS as well. The prescriber has to be confident that it has excluded those kinds of conditions before prescribing this drug. And the standard of care around the world, most medication abortion occurs without an ultrasound. Thanks.
Justice Jackson.
Good morning, General. So I'm worried that there is a significant mismatch in this case between the claimed injury and the remedy that's being sought, and that might or should matter for standing purposes. I don't know that our doctrines sort of capture this, but I guess I see it that the injuries that the respondents allege, as you've articulated them, are a conscience injury, that they are being forced to participate in a medical procedure that they object to. And so the obvious common sense remedy would be to provide them with an exemption, that they don't have to participate in this procedure. And you say, and you've said here several times, that federal law already gives them that. So I guess then what they're asking for in this lawsuit is more than that. They're saying because we object to having to be forced to participate in this procedure, we're seeking an order preventing anyone from having access to these drugs at all. And I guess I'm just trying to understand how they could possibly be entitled to that given the injury that they have alleged.
I agree, Justice Jackson, and I do think it's relevant to standing. There's a profound mismatch here between the claimed injury and the remedy they were seeking. And, you know, you can almost think of this as a type of zone of interest kind of analysis. You know, if the doctors have a conscience injury, there's a specific statute designed to deal with it, to specifically tailor-made guard against the risk of that injury occurring. And instead, they're reaching out and seeking to invoke rights under a different statute, the FDCA, that doesn't regulate them at all, that doesn't make them do or not do anything, and the relief that they're seeking would dramatically alter the approved conditions of use for mifepristone and affect women all around the nation simply because of this conscience injury that's already directly addressed by other protections.
Right, and if it wasn't addressed, then we would see this lawsuit, and the remedy would be to exempt them. Right?
Yes. I mean, I think that one of the hard things about trying to tailor relief here is that they're asserting such a diffuse theory of injury that it's almost as though the only option was to grant a nationwide remedy of the kind the lower courts issued. And that runs counter to ordinary Article 3 principles of party-specific relief. But I just think it shows that there's something wrong with the theory of injury in the first place because it's so attenuated and because they claim they would need so much relief all over the country.
Let me ask you another question. In addition to the challenges that we have here, the respondents below challenged the FDA's initial decision to approve mifepristone in the year 2000. Of course, that occurred a very long time ago. The Fifth Circuit found that challenge wasn't timely because of the statute of limitations. As you're aware, in the context of another case we heard this term, the court is currently considering the statute of limitations issue. So setting aside standing, have you thought about how a ruling from this court on the statute of limitations in either direction might impact what happens in these kinds of cases with these kinds of challenges?
Yes, I think that it just reflects the stakes of the corner post case and provides a vivid example of the way that it might be possible if this court were to approve the request for a broader theory of the statute of limitations in that case, the way it could open the door to plaintiffs coming in and saying, well, I only became a doctor later, or I only started working in an emergency room later, and would try to unsettle longstanding agency actions that maybe occurred decades previously. I do want to say that I understand the corner post petitioner to have suggested maybe there would be equitable defenses that the government could raise in those kinds of cases. We would certainly want to raise that type of defense with respect to the approval of mifepristone, which I think has generated tremendous reliance interests and proven to be safe and effective over decades of use.
Thank you.
Thank you, counsel. Ms. Ellsworth.
Mr. Chief Justice, and may it please the court. In 2016 and 2021, FDA made certain changes to the labeling and use restrictions for Danco's drug Mifeprix. The decision below stops Danco from selling Mifeprix in line with that scientific judgment based on a highly attenuated claim that an unknown doctor could be called someday to an unknown emergency room after a series of decisions by third parties. No facts causally link that possible future encounter to a specific change FDA made in 2016 or 2021. Respondents' view of the Food, Drug, and Cosmetic Act is so inflexible it would upend not just Mifeprix, but virtually every drug approval and REMS modification FDA has made for decades. Reversal is required for two reasons. First, Article 3 standing is not an academic exercise in what's conceivable. Respondents lack standing under every prong of the analysis. Second, on the merits, FDA exhaustively considered the evidence and reasonably explained its conclusions, which is what is required to do. I welcome the court's questions.
The government, the Solicitor General points out, would not be susceptible to a Comstock Act problem. But in your case, you would be. So how do you respond to an argument that mailing your product and advertising it would violate the Comstock Act?
Justice Thomas, we agree very much with the government that FDA's charge under the Food, Drug, and Cosmetic Act is limited to looking at safety and efficacy considerations. That's true for new drug approvals. It's also true for REMS modifications. FDA routinely approves drugs whose manufacture and distribution is restricted by other laws, like the Controlled Substances Act, environmental laws, customs laws, and so on. I think this court should think hard about the mischief it would invite if it allowed agencies to start taking action based on statutory responsibilities that Congress has assigned to other agencies. On the merits, this issue was not presented below, was not ruled on below. And in any event, I would also point out that in 2021, FDA's decision allows use of brick and mortar pharmacies in addition to mail order pharmacies.
Well, my problem is that you're private. The government, I understand the government's argument, but you're private, and the statute doesn't have this sort of safe harbor that you're suggesting. And it's fairly broad, and it specifically covers drugs such as yours.
Your Honor, we disagree that that's the correct interpretation of the statute, but we think that in order to address the correct interpretation, there would need to be a situation in which that issue was actually teed up. This statute has not been enforced for nearly 100 years. I don't believe that this case presents an opportunity for this court to opine on the reach of the statute.
Counsel, I'd like to ask you the same questions I was posing to the Solicitor General. You know, our precedents, Clapper and Susan B. Anthony list, talk about requiring a substantial risk that harm will recur, and you argue that's not present here. How are we supposed to find the spot at which the risk becomes substantial?
Your Honor, I think this court has always thought about these standing inquiries as really a question of degree. And you're trying to evaluate whether something is actual and imminent or whether it's conjectural and hypothetical. And these terms, substantial risk, certainly impending, which has been used dating all the way back to 1923, get at where a claim falls in this spectrum.
Right. I mean, we toss around a lot of adjectives, but I'm just trying as a practical matter, how do you figure out? I mean, what percentage of adverse consequences would be enough? What percentage of emergency room visits would be enough?
I think the way Clapper got at that question, and you can see this in footnote 5 of the opinion, is to really think about whether there is an attenuated chain of contingencies that have to happen. And in situations where there is this kind of attenuated chain of circumstances involving third-party decisions that have to play out in a particular way, and here that chain is quite long, that squarely puts a plaintiff's theory on the side of the conjectural or hypothetical and not the certainly impending injury.
How is your company aggrieved by the challenge that is brought in this case? I gather this is your version of mifepristone is the only product you are currently marketing. Is that right?
That's correct, Justice Alito.
And the Fifth Circuit decision does not prohibit you from continuing to produce and sell that product, right?
That is correct.
All right. And so I gather your injury is that you think you're going to sell more if the restrictions that previously were in place were lifted.
Yes.
So you're going to make more money.
The injury is that we are prevented from selling our product in line with FDA's scientific judgment about the safe and efficacious use of the drug.
And you're going to be harmed because you're going to sell more.
I think that certainly a company's ability to market its product is a part of how it considers the regulatory scheme that governs its conduct.
During the questioning of the Solicitor General, the statement was made that no court has ever previously second-guessed the FDA's judgment about access to a drug, right? And it's never second-guessed that.
That's correct.
Do you think the FDA is infallible?
No, Your Honor. We don't think that at all. And we don't think that question is really teed up in any way in this case.
Has the FDA ever approved a drug and then pulled it after experience showed that it had a lot of really serious adverse consequences?
It has certainly done that. And, Your Honor, I think that underscores why the adverse event reporting, the post-market surveillance that FDA does, the ability that these plaintiffs have, even if they don't have standing, certainly if they are seeing patients who are presenting with adverse events, if they are doing studies that show there is some unknown safety component that FDA should acknowledge, they can take significant steps to bring that to the agency's attention, to bring that to Danco's attention.
But don't you think the FDA should have continued to require reporting of non-fatal consequences?
Your Honor, the FDA decided not to continue that reporting requirement in 2016 based on more than 15 years of a well-established safety profile when that reporting was required. There is no drug on the market today under any REMS that requires the kind of reporting that the plaintiffs are saying should be reimposed here.
So why would that be a bad thing? Wouldn't your company, I mean, you don't want to sell a product that causes very serious harm to the people who take your product relying on your tests and the FDA's tests. Wouldn't you want that data?
Your Honor, that data is certainly something that we are looking for all the time. It is part of the reporting obligations for a manufacturer to be aware of any data that's becoming available through any means. We have a 1-800 number on our website. There's a 1-800 number on the labeling. I think Your Honor's question, though, gets at concern I heard in some of the earlier questioning about who would have standing if these plaintiffs don't have standing. And one of the things I want to note is that drug manufacturers are very frequently subject to tort litigation. Product liability suit, failure to warn suits, deceptive advertising suits when someone is claiming harm from a pharmaceutical manufacturer's product. What is so, I think, revolutionary really about the arguments here, both on standing and the merits, are the way that they attempt by individuals who do not use this product, do not prescribe this product, and have a conscience right not to treat anyone who has taken this product. Those individuals want to prevent anyone else from using it in line with FDA's considered scientific judgment.
Does your company, just one more point along the same lines, does your company think that what the FDA has done preempts state laws that prohibit the dispensation of mifepristone within their borders?
We have not taken a position on that issue, and it has not been teed up in this case.
What is your company's position on it? You haven't even thought about it? One of your competitors made that argument, right?
That's right. There are some lawsuits that have been brought by the generic company that do make that argument, and I think that is for later courts to sort out. Our position in this case has been that this is about FDA's scientific judgments reached in 2016 and 2021.
So you don't want to answer that question?
I don't think we have a position that's on that I'm prepared to say today.
Could you go back to Justice Alito's questions about adverse event reporting? And you said you were subject, your product, to higher standards, and now we're being brought down to the sort of regular. Could you talk about that a little bit? What are the normal standards for adverse event reporting as you understand them? Why are they there? What instead were you subject to in the past?
May I answer the question? Justice Kagan, what changed was not Danco's adverse event reporting responsibility. Danco's adverse event reporting responsibility has been the same throughout this period. What changed was that from 2000 until 2016, prescribers were obligated to report adverse events to Danco, and then Danco then had its separate reporting obligation to FDA. So in 2016, the REMS for mifepristone were aligned to be more consistent with the reporting requirement that applies to all 20,000 plus FDA-approved drugs. There are only today 7 REMS that continue to have even the limited higher adverse event reporting for deaths that apply to mifepristone. So it is only one of 7 that have that.
Thank you.
Justice Thomas? Justice Alito? Any further? Justice Sotomayor? Justice Kavanaugh? Justice Barrett? Justice Jackson? Anything
I just
further?
have one quick question. So you were asked if the agency is infallible, and I guess I'm wondering about the flip side, which is, do you think that courts have specialized scientific knowledge with respect to pharmaceuticals, and as a company that has pharmaceuticals, do you have concerns about judges parsing medical and scientific studies?
Yes, Your Honor. I think we have significant concerns about that, and there are 2 amicus briefs from the pharmaceutical industry that expand on why exactly that's so concerning for pharmaceutical companies who do depend on FDA's gold standard review process to approve their drugs and then to be able to sell their products in line with that considered judgment.
Can you say a little bit about what they say?
I'm happy to. I think the reality is, and this court is this decision below is a good example of it. You have a district court that, among other things, relied on one study that was an analysis of anonymous blog posts. You have another set of studies that he relied on that were not in the administrative record and would never be because they post-date the FDA decisions here. They have since been retracted for lack of scientific rigor and for misleading presentations of data. Those sorts of errors can infect judicial analyses precisely because judges are not, they are not experts in statistics. They are not experts in the methodology used for scientific.
You're listening to the Supreme Court as it hears arguments weighing whether it's legal to allow the abortion pill mifepristone to be sent by mail without an in-person doctor's visit. The high-stakes challenge to the FDA is the first major abortion case to go before the Supreme Court since Roe v. Wade was overturned 2 years ago. Let's bring in senior congressional correspondent Rachel Scott at the Supreme Court and ABC News legal contributor Kim Whaley for more. Rachel, we're hearing a lot of back and forth over how the decision came to be to relax the restrictions on mifepristone. What's at stake with these arguments today, and what sticks out to you from what you've heard so far?
Yeah, so much is at stake because what the justices could ultimately decide would impact a woman who want to get access to the abortion pill mifepristone, even in states where abortion is legal. I've been taking some notes as we've been listening to these oral arguments, so forgive me for just looking down at what we had just heard. The counsel for the Justice Department, arguing that the FDA relied on dozens of studies involving tens of thousands of women, arguing that there is no evidence that the FDA overlooked anything, going on to say that women should not be forced to undergo more invasive surgical abortions, which may happen if the FDA or could not or has to roll back some of these restrictions that are currently in place, and then going on to argue that others might not be able to access the drug at all, making a nod at the far-reaching consequences that could be sweeping if the Supreme Court and if these justices decide that those restrictions need to be put back in place. She called on the justices to reject that standing. Now, of course, Diane, as we've been talking about all morning, we wanted to pay close attention to what the justices were asking, especially having our eyes on Justice Amy Coney Barrett. She asked if there's more risk if you do not see a doctor. Remember, now with the current, what is currently in place, if you want to get access to the abortion pill mifepristone, you don't have to do those 3 in-person doctor visits. You are able to get the drug prescribed by mail. All of that obviously could change based off of what the justices decide. We heard from the Justice Department saying the FDA ultimately concluded it could be dispensed without those in-person visits. We heard Amy Coney Barrett then ask if it was a required condition to receive an ultrasound when you were at the doctor's office, when you wanted to get the pill prescribed. She then went on to say that the FDA has always left that up to medical judgment. Then on the other end, and what we just sort of heard before you brought us in for this roundtable here, we heard from Justice Jackson. She was asking the lawyer representing a company who makes these pills if she has concerns about judges getting involved in the scientific study. And that underscores sort of really what so many in the medical community are talking about here, that if the justices decide to weigh in on this, what is next? Could they go after potentially other drugs that the FDA has approved? So it really underscores what's at stake in this hearing that we're seeing take place before the Supreme Court today, Diane.
Kim, the Alliance for Hippocratic Medicine is trying to say that the FDA overlooked safety concerns in deciding to relax these restrictions. But before they can even go into that, they have to show they have standing to sue here. And I want to expand a little bit on one thing Rachel just said, because there was this interesting moment with Justice Jackson where she talked about her concerns about a profound mismatch between what these complainants are claiming is their injury and the remedy that they're seeking. And she's essentially saying these doctors are saying that they are, against abortion and so they should not have to participate in this procedure. And federal law already protects them from having to do so against their will. So why would that entitle them to seeking that this remedy be, that this pill be unallowed entirely in terms of being able to prescribe it by mail and without an in-person visit? What did you make of that exchange in terms of whether this group has standing to bring this suit to begin with?
Listen, Diane, I mean, this is really sort of the monster in the closet in this case and in a series of cases with the Supreme Court. The big issue is the power grab that if the court agrees with the challengers here, the power grab of these unelected justices in taking what amounts to a case involving policy. Congress gave the agency the power to regulate drugs. And that standing doctrine, that idea of requiring someone who's actually injured to bring the case case, that's designed, and Justice Scalia was the architect of the modern doctrine, that's designed to keep judges out of the business of legislating and making policy by requiring someone with an actual broken arm, someone who's really hurt and injured in a unique way. And here, the tangential nature of some kind of psychic, religious, spiritual injury is so attenuated with no evidence in the record that any doctor has ever been in that sort of moral conundrum in giving a woman some kind of medical care who use these very, very safe drugs. What Justice Jackson is saying is we've just blown the gates open to handing the Supreme Court kind of the power of the United States. I mean, that's really the bigger issue. And the court has already done this. It did it in the Biden student loan case. It did it in the 303 creative case involving making a hypothetical website for a hypothetical gay couple. The court is ignoring that basic separation of powers question. And that's the bigger issue. Lots of implications here for women seeking this kind of care, but even bigger issues for whether the Supreme Court of the United States is going to become the ultimate lawmaker, decider, regulator without the expertise for the United States, with no way of kicking them off at the ballot box. It's a really, really big core constitutional issue that's playing out right now.
All right, Rachel Scott, Kim Whaley, thank you both. And we're going to listen back into that hearing in just a minute. But first, we also want to get to some breaking news. An urgent search is underway after a cargo ship crashed into a Baltimore bridge, sending cars, people, and part of the Francis Scott Key Bridge into the water. Authorities say it happened around 1:35 this morning as the ship was leaving Maryland. The Maryland governor says the ship reported a power issue and sent a Mayday signal before hitting the bridge. Officials now say they are looking for 6 people unaccounted for. 2 more people have been rescued. And according to the FBI, there is no credible information to suggest any ties to terrorism. They are considering this an accident. I want to bring in ABC's Ike Ajachi, who's there in Baltimore with more. Ike, what's the latest?
That's right. The latest right now is the intensity at which this search effort is currently being conducted. You said it right there, right now. 6 individuals unaccounted for, but altogether, this was an 8-member crew that was on the bridge at the time of the collision. And if you could take a look right now, the remnants of that collision is still alive and present. You can see that large container ship still stuck in the middle of the Francis Scott Key Bridge. Debris of the bridge encircling the container ship, preventing it really from moving from its position. You said it yourself, there is a propulsion issue as soon as this large container ship left the port, which resulted in the crew not being able to essentially have power or control that vessel, which led to its collision to that Francis Scott Key Bridge. Now, right now, the focus is the response, and the latest news from state and local officials is that this is an all-encompassing response. Local, state, and federal officials essentially coming to this area and searching everything from the skies. There's currently helicopters in the skies right now, obviously the land, but most importantly, the sea. We're being told that the Army Corps of Engineers provided assistance for searching below the surface of the water. We know that sonar was essentially used to see how many cars could still be trapped underneath that water. Now, again, we do know that there are 6 people unaccounted for, but federal officials also said that there could be upwards of 20 people still missing. Now, the question was arise whether or not there could be any possibility of anybody still stuck in their car at the bottom of this river here. We're being told that because of that sonar, it's safe to say that that isn't the case. But again, that 8-person crew right now, 6 of those individuals are unaccounted for. 2 of them have been rescued. 1 person is okay, and that 2nd person is in serious condition at an area hospital here.
And Ike, this is a major shipping port, so the ramifications here, the implications will be felt far and wide. But officials are saying that they got that Mayday signal in time to stop traffic on the bridge before the collision. So it sounds like this could have been a lot worse.
This really could have. Now, we're being told that this ship was traveling at 8 knots, which is about 9 miles per hour. And a ship at this size, we're being told that's a considerable speed. Now, imagine a ship that size traveling at that speed, that Mayday signal that was delivered to the bridge, the officials on the bridge, they then took that signal and stopped traffic. We're being told that that one action of stopping traffic saved dozens of lives. So many more people could have been on that bridge when it went down into the Patapsco River right here behind me. But thankfully, a lot of those people essentially were stopped before they got to the apex of that bridge. Now, again, if you watch, there's video circulating online showing a long version of this entire collapse. Minutes up into the collapse, you can actually see lights going across the bridge. That means traffic was heavy. But because of that Mayday signal, the moments right before that crash, you could see the traffic on the bridge was essentially quelled. There wasn't that many people on the bridge. That's an indication that that Mayday symbol did its job, alerted the people on the bridge, and thankfully had a lot more people off the apex of that bridge, which essentially prevented so many more people from being caught in the middle of this entire disaster.
All right, Ike Ajachi, thank you. And we will have continuing coverage of the bridge collapse all day long here on ABC News Live. And the Supreme Court is hearing arguments as it weighs whether it's legal to allow the abortion pill mifepristone to be sent by mail without an in-person doctor's visit. The high-stakes challenge to the FDA is the first major abortion case to go before the Supreme Court since Roe v. Wade was overturned 2 years ago. This pill is the most common way to end a pregnancy, and a change in access could have major implications for millions across the country, even in states where abortion is still legal. And that Supreme Court hearing is underway right now. Let's listen in.
We've had, one might call it a rash, of universal injunctions or vacatures. And this case seems like a prime example of turning what could be a small lawsuit into a nationwide legislative assembly on an FDA rule or any other federal government action. Thoughts?
Yes, Your Honor. Again, I have to say that I think it's impracticable to raise a conscious objection. But even spotting that, I think the district court remedy here was perfectly appropriate under Section 705. Section 705 grants the reviewing courts the authority to issue all necessary and appropriate relief. And as the government acknowledged in oral argument in Corner Post, when the parties before the court are non-regulated parties, the only avenue in which they can possibly get relief, and of course that's sort of the sine qua non of equitable relief, is that the parties before the court get it. And that's for, as in this case, a state issue, or in other cases, a vacature. And that's because without that sort of relief, the very parties before the court won't get it.
I think
why can't the court specify that this relief runs to precisely the parties before the court, as opposed to looking to the agency in general and saying, agency, you can't do this anywhere?
So I think, Your Honor, that might be impracticable. If we're thinking again about the emergency room situation, would Dr. Francis again have to know when she's in the emergency room whether this is a miscarriage, an ectopic pregnancy, or an elective abortion? This is what she does day in and day out. And so it seems like to say that these would run two particular plaintiffs would be missing, that the FDA regulations would still be in place and permit things like mail order abortions. They would have removed the reporting requirements. And if we look at the merits of what FDA did in 2021, FDA relied on two things. They relied first on the FAERS data.
Counsel, before you pivot back to the merits, and I can understand your impulse there, but I went back and looked, and there are exactly 0 universal injunctions that were issued during Franklin Delano Roosevelt's 12 years in office, pretty consequential ones. And over the last 4 years or so, the number is something like 60, and maybe more than that. And they're a relatively new thing. And you're asking us to extend and pursue this relatively new remedial course, which this court has never adopted itself. Lower courts have kind of run with this. And I just want to give you one more shot at that.
Sure, Your Honor. So again, the APA, of course, encapsulates equitable remedies. And as Pomeroy and others have said from the beginning of the 19th century, equity requires that the parties before the court get relief. In this instance, again, as the government pointed out in Corner Post, where you have non-regulated parties, those parties could be farmers, they could be ranchers, they could be the seed farms in Gertsen. But their only availability for relief is if the court does something to the FDA order or regulation at issue. Otherwise, those parties are simply out of luck, and that's inconsistent with equity.
May I ask Ms. Holy about your basic theory of standing? And just, this is a clarification question as much as it's anything. When you did your 1, 2, 3 in your opening statement, it sounded very probabilistic to me. I mean, I don't remember exactly what the 1, 2, 3 are, but, you know, let's say it's something along the lines of, we represent a lot of doctors, and there are a lot of women out there taking mifepristone, and some fraction of them are going to have adverse events, and some fraction of those are going to come to the emergency room, and so there's some probability or likelihood that one of our doctors who has a conscience objection is going to come face to face with one of these women who has an adverse event. Is that your theory?
No, Your Honor. What we think really shows that respondents have standing here is FDA's own acknowledgments. I would point you to JA 384. And in regulating mifepristone, FDA has continually said that emergency room doctors and OBGYN hospitalists are critical to the safe use of drugs.
Well, I think then it is your theory. I mean, you're just saying even FDA admits that there are going to be some adverse events. People are going to show up in emergency rooms. People are going to come face to face with one of our doctors who objects to some aspect of the treatment. That's the theory, yes?
Well, we certainly think all of that is true, but we don't think it's a problem with probabilistic standing, as was the case under Summers, for 3 reasons. First, Summers involved unidentified members. Here we have 7 named plaintiffs. In addition, and no one in Summers, at least that was still part of the case.
So does your theory really depend on your having at least one person? Because I take Summers to be saying these probability theories, they sound very nice. They have nothing to do with our Article 3 requirements. You need a person. You need a person to be able to come in and meet the court's regular standing requirements. So you agree with that, yes?
I think that's correct, Your Honor, yes.
Okay, so who's your person? I know you have 7 of them, but if you had to pick one and say, go read that declaration, and that declaration is going to tell you why we're entitled to be up here. Who's the person?
So I have to pick 2, Your Honor, but Dr. Francis and Dr. Scott.
Okay, and what about those 2 doctors gives you the kind of imminent injury, let alone the traceability, that we've typically required?
So to speak to Dr. Francis at the beginning, there's been some confusion, I think, about the precise nature of the conscience harm. But if you look at JA 155, paragraph 15, she talks about her and other APLOG members who object not only to taking the life of an unborn child during an elective abortion, but also to, quote, completing that process. That echoes the CMDA declaration at 142 and 143. It's also consistent with...
Has she ever been, because I read that declaration pretty carefully. What actual emergency treatment has she participated in that she objects to and that she has stated an objection to?
So the prior page, Your Honor, JA 154, talks about a DNC, which she was required to perform due to a life-threatening emergency.
She herself performed that.
That is correct, Your Honor.
And did she have an opportunity to object? Did she object?
No, Your Honor. Again, these are life-threatening situations in which the choice for a doctor is either to scrub out and try to find someone else or to treat the woman who's hemorrhaging.
Well, usually conscience objections, the way people with conscience objections do this, is they make those objections known. And, that may be harder, it may be easier in a particular context, but most hospitals have mechanisms in place, routines in place to ensure that doctors who are allowed to do this, in advance, right, and are allowed to do it at the moment, they say so. And when I looked at Dr. Francis's and Dr. Scott's, there's just nothing that you have there that suggests, this is like there are, other requirements that you need. But at the very least to be able to say, well, this happened to them in the past, I don't think you have it for either one of those doctors.
So I think we do, Your Honor. Given the emergency nature, it's simply impracticable to have a objection lodged prior to understanding what's going on in that operating room. And again, I'd point, Your Honor, to the District Court Fifth Circuit brief in EMTALA, where the government says that neither the church nor any of the other sponsors of those federal conscience protections intended them to apply in emergency situations. So it's a lot to ask our respondent doctors to go up to the top floor and litigate this with the general counsel when the federal government's telling them they don't have a conscience protection.
Is it true that our standing decisions have not relied on probabilistic determinations like the Department of Commerce case? The court said there was standing because if a question about citizenship was included on the questionnaire, a certain percentage, an unknown percentage of residents would then not fill out the census at all, and therefore it was probable that there was some risk that New York State would risk losing a representative in the House of Representatives or would risk losing money under some federal program, and you put together this chain of probabilities, and that was sufficient to establish standing.
Absolutely. We agree with that, Justice Alito. In particular, you can look at the Gertsen Seed Farms case, which also involved non-regulated parties. And this court looked at the distance that bees might fly in order to pollinate seed farms. So it's certainly true that data is appropriate to consider in determining whether there's a substantial risk under SBA list. Here, the FDA admits, this is at 533, that between 2.9 and 4.6% of women will go to the emergency room. It acknowledges, this is at 542, that up to 7% of women will need surgical intervention. And when the FDA talks about there being no increase in adverse events from the increased gestational age, the only way they can say that is by ignoring surgical interventions. And that's because at JA 207, the FDA...
Counsel, what do we do with the fact that these two people that you rely on, Francis and Scope, that Indiana and Texas have abolished abortions and abolished them by pills or otherwise. Now, we can get into whether other people are illegally breaking the law and supplying it contrary to law, but what does that do to your probability? Which is, it's already infinitesimally small because there are thousands of hospitals in the country, 50 states, I don't know how many territories, thousands and thousands of places where pregnant women go who may be suffering from miscarriages or otherwise, to know or to even imagine how one doctor is going to ever actually see a patient that that he or she is going to be forced to intervene on their behalf, but then add to it that this is illegal in these states.
So I think the best answer, Justice Sotomayor, is that past is prologue. In our declarations, we have 3 doctors who have treated harms from abortion drugs at least a dozen times. We have 2 examples when women went out of state. And if you go out of state, there's a higher likelihood you're not going to have a follow-up visit. What the FDA's regime has done is turn ER rooms into those follow-up visits. We've had that happen with both Dr. Jester, where a woman went to New Mexico and returned to Texas, as well as Dr. Johnson, where a woman went to Illinois and returned to Indiana. Indeed, according to Guttmacher, 1 in 5 abortions take place out of state in surge states like New Mexico, like Illinois, the border states in which our doctors reside.
Ms. Hawley, can I take you back to the affidavits and some of Justice Kagan's questions? You were talking about Dr. Francis. And as I read her allegations, or as her affidavit reads, she said that her partner was forced to perform a D&C when there was a living fetus. And she said she performed a D&C on a woman who was suffering serious complications. But the fact that she performed a D&C does not necessarily mean that there was a living embryo or a fetus, because you can have a D&C after, a miscarriage. So if that's right, I mean, I think that the difficulty here is that, at least to me, these affidavits do read more like the conscience objection is strictly to actually participating in the abortion to end the life of the embryo or fetus. And I don't read either Scott or Francis to say that they ever participated in that. So do you want to address that?
Sure. So first, Justice Barrett, I think Dr. Francis's combined with CMDA can be read for the broader conscience harm. Again, that's how the district court understood that. I'd point you to pages 7 and 8. That's how both the state panel and the Fifth Circuit understood respondents' conscience harms to extend beyond simply requiring the ending of an unborn life. And with respect to even the more narrow conscience harm, to whether a doctor may need to end a life, we think there's still a substantial risk of that occurring. If you look at the numbers of the increase from 7 to 10 weeks in gestational age, that means that 3.1% of pregnancies will be ongoing, requiring a DNC. We know at ROA 870 that 55% of those DNCs occur in the emergency room. This is a substantial number of women suffering abortion drug harm. Again, Guttmacher says 650,000 women took the drug in 2023.
But not all those DNCs will involve a pregnancy that would otherwise be viable or an embryo or fetus that would otherwise be living, because you can have complications or excessive bleeding even after the abortion is complete in that respect, but there's pregnancy tissue remaining.
So with the 3.1, Your Honor, is ongoing pregnancy.
Is ongoing pregnancies.
And FDA says at JA 542 that up to 7% will need surgeries to stop either bleeding or ongoing pregnancies or failures.
How many members of your organization? You have a broad number of, doctors that are in your organization. I gather dentists, some doctors who are retired. How many members of your organization are OBGYNs who practice in hospitals who might be called into these ERs?
There are hundreds of them, Your Honor, but I think, may I finish? Sure. I think in particular that the named plaintiffs are OBGYN hospitalists who spend most of their time on the labor and delivery floors, but also are called to the OR to treat these sorts of emergencies.
Ms. Hawley, can you clarify the broader conscience harm from the narrow one? Because I had understood the conscience harm as Justice Barrett does, but you suggest that there's a broader one. So what is that?
Yes, Your Honor. I'd point you to pages 7 and 8 of the district court opinion. And the district court understands the conscience harm to be either taking the life of an unborn child, which would sometimes be required. Dr. Francis testifies to a partner who was required to do that because of emergency situations.
That's what I understood the narrow one to be, right? I'm participating in a procedure that is ending the life.
Yes. I think that's
narrow. Okay, yes. So what's the broader one?
So the broader one, Your Honor, is being complicit in the process that unnecessarily takes an unborn life, such as performing DNC and abortion. And it's really not that hard to see.
No, wait, I'm sorry. Complicit like I work in the emergency room and this is going on. I'm handing them a water bottle. I'm like, what do you mean complicit in the process?
So this court, of course, takes religious beliefs and conscience beliefs as it finds them. But what harms our doctors, Your Honor, is being involved in completing, in the terms of our declaration, an elective abortion. And it's really not that hard to see why that might be a conscience harm if you think about what's involved in a DNC.
But you just said, again, it's being involved in completing an elective abortion. So I took that to be the conscience objection. I think what Justice Jackson is asking, or what I asked before, or what Justice Barrett is there any broader conscience objection that appears, I'm not sure I care all that much about the district court, but that appears in the declarations?
Yes, Your Honor. And in this sense, completing an elective abortion means removing an embryo fetus, whether or not they're alive, as well as placental tissue. Again, Dr. Francis talks about being required to perform a DNC, this is at 154, and remove placental tissue.
Whether or not there's any live tissue?
Yes, Your Honor. And again, this makes sense.
And where are we looking for that?
So I would point, Your Honor, to JA 155, paragraph 15, where again she talks about completing an abortion. The CMDA declaration at pages 142 and 143 also describe this sort of complicity harm from being involved in an elective abortion, Your Honor. And again, these doctors performing a DNC must scrape out a woman's uterus of a child, of the embryo, the fetus, or placental tissue. And this court has recognized harms like that in cases like Little Sisters of the Poor, as well as Hobby Lobby.
No, go ahead.
It's my understanding that sometimes the completion, it doesn't involve surgical intervention. Do you have a sense of how often? I mean, we may get all the way down the chain to the doctor is there, the person is having an emergency procedure. My understanding is with some of these chemical abortion scenarios, the completion occurs by prescribing additional medication. Do you have a sense of how many times the completion is that route and could be done by another physician as opposed to your clients in doing a medical procedure?
So that second dose, Your Honor, of misoprostol has been part of the regimen since 2016, really I think all the way back to 2001, but it's been approved by FDA since 2016. So the best numbers we have from FDA are still consistent with that, and that means that 3.1% of pregnancies at 10 weeks will be ongoing. I'd encourage you to look at JA 405 through 407, and this explains that these risks go up without an in-person visit.
Yeah, no, I guess I'm just trying to get at, I'm still working on how many circumstances or how often it would be that your clients actually have to complete the procedure in the way that you are describing.
So Dr. Scott talks about doing this at least a dozen of times, either a DNC or a suction aspiration abortion to remove, again, embryos, fetuses, or placental tissue. In addition, Your Honor, if you think about the numbers, again, it says 3.1% at 10 weeks, and this has only gone up. In 2020, FDA told this court that the in-person visit was both, quote, necessary and minimally burdensome, and necessary to preserve women's health, precisely so these sorts of situations occur less frequently.
Thank you, counsel. Justice Thomas.
Ms. Hawley, I'm sure you heard the answers of the Solicitor General and the counsel for Danko with respect to the Comstock Act. I'd like you to comment on their answers.
Sure, Justice Thomas. We don't think that there's any case of this court that empowers FDA to ignore other federal law. With respect to the Comstock Act is relevant here. The Comstock Act says that drugs should not be mailed either through the mail or through common carriers. So we think that the plain text of that, Your Honor, is pretty clear.
When did you first raise the Comstock Act?
So I believe the Comstock Act was first raised at the district court, Your Honor, but we think that exhaustion does not apply for two reasons. First, it would be plainly futile as FDA's adoption of the OLC memorandum goes. In addition, this is a whole other kettle of fish, but if you look at Section 704, exhaustion is only required in two instances, either when required by a statute or when by an agency rule, when that agency rule is stayed pending litigation. This is consistent with this court's case in Darby. The lower courts have taken conflicting opinions, but we think the better reading of Section 704 is that there's no exhaustion required unless either a statute or agency rule stays the proceeding during judicial review.
Justice Alito? Justice Sotomayor? Justice Kagan?
May I ask about your view of traceability? And, you know, on one understanding, and I want you to tell me if you agree with this, that even beyond proving whatever injury you're trying to prove, that you have to show that that injury is traceable to the 2016 and 2021 FDA actions that you're challenging. And of course, that means showing that these incidents that you're talking about in the emergency room are caused by whatever incremental increase in risk there is as a result of those 2016 and 2021 actions. And I guess my first question is, do you agree with that statement of what you need to show? And if you do, how do you satisfy that? Why do you satisfy that?
So we believe, Justice Kagan, under the case law, that we need to show that each the 2016 action and the 2021 action increase the risk of harm. And we think the way...
But then I guess what I'm saying is that you have to link whatever injury your members have to that increased risk. Do you agree with that?
We do, and we think we can do that for a couple of reasons. First of all, traceability, of course, is de facto. We're not in the Paul's graph sort of world of tort causation. And when you look at the 2021 action, we think traceability is satisfied by FDA's own words. It says at JA 405 that without the in-person visit, this is the Anger study, without that in-person visits, ER and other medical care is likely to increase, as well as surgical interventions. And these are the very same surgical interventions that harm respondent clients.
So there might be some dispute between the two of you as to exactly how big the increased risk is, but let's even take your view that there is, some measurable increased risk. How do you connect that risk to particular actions that your members have, to particular injuries that your members have undergone or imminently will undergo? I mean, it could be, the original risk.
So I think the declarations are actually quite clear on this. If you look at Dr. Francis's declaration, she says that when the in-person visit was enjoined in 2020 by a federal district court, that she saw an increase in emergency room visits from abortion drug harm. Dr. Johnson, Dr. Scott say the same thing. And again, this is entirely consistent with FDA's own numbers. Again, in 2020, FDA told this court that the in-person visit was necessary to preserve women's health because an in-person visit is the best opportunity to examine for things like ectopic pregnancy and accurately assess gestational age.
Thank you.
Justice Gorsuch? Justice Kavanaugh? Justice Barrett?
So General Prelager said that initial in-person visit had no requirement of an ultrasound or, any effort to detect fetal heartbeat. So it wouldn't necessarily give an accurate read on gestational age or detect an ectopic pregnancy. So why would that why would the elimination of the visit necessarily increase the risks?
So I think, Your Honor, FDA's own data shows that those risks did go up. If you look at the Caresti study, it shows a nearly threefold increase in emergency room visits when you have the in-person visit and when you removed it. There was 5.8% with an in-person visit, and it was also in about 2.1 without.
Is that because doctors were just kind of voluntarily saying, hey, it would be a good idea to give you an ultrasound or try to detect a fetal heartbeat, or what?
So when FDA removed the in-person visit, Your Honor, it took away the opportunity to do that. I think ACOG, I think medical organizations agree that is best practice. So if a woman comes into a doctor's office, she's likely to get an ultrasound to accurately assess both ectopic pregnancies, diagnose or assess gestational age. But what's allowed under FDA's rules currently is to be able to order these online with a couple of screening questions. And I don't think that's nearly as good as an in-person exam.
Let me just pivot to the organizational standing question. So let's say that I'm just going to carve out and put aside the costs of filing a petition or litigation as harms to your organization itself. Explain to me what additional costs you might have incurred or how your resources were diverted in a way that would satisfy Havens.
Absolutely, Your Honor. So putting to one side the citizen petition, the APLOG declaration is clear that respondent organizations conducted studies and analyzed studies. This included going through the Medicaid data. It included going through the FAERS data to the extent it was available.
Is that it?
Well, those studies, Your Honor, I would point to one of them is at ROA 870 and before and after. And those are pretty comprehensive studies, Your Honor.
And are they to the end of the litigation and the citizen petition, or what are they to the end of?
To accurately assess the harm from abortion drugs, Your Honor. So I think it's absolutely separate from the litigation. And one thing to note with the citizen petition is that is the only way in which anyone can raise a concern to the FDA. These proceedings go on between DANCO and the FDA behind closed doors. This is not a notice and comment process. The first time anyone can raise these objections is a citizen petition.
Justice Jackson?
So what deference, if any, do courts owe the opinion of the expert agency concerning the safety and efficacy of drugs?
So under this court's administrative procedure precedents, Your Honor, APA review, of course, is not toothless. Instead, in this case, we're not asking that the court second-guess the agency determinations at all, but rather look at what FDA said. Again, in 2021, when FDA took away the in-person visit, it did so based on FAERS data. It says elsewhere cannot be used to calculate the incidence of an adverse event, as well as studies that says that JA 407 are, quote, not adequate.
I guess I don't understand how that scope of review is not second-guessing the agency. I mean, they're looking at studies, and you're saying that the court can look at studies, maybe different studies, maybe the same studies, and critique their conclusions about them.
So what deference do we owe them at all with respect to their assessment that these studies establish what it is that they say they do about safety and efficacy?
I don't think that's an accurate portrayal of the APA claim at issue here, Your Honor. And the reason being, again, is we're just asking this court to look at what FDA said. The FDCA says you have to have adequate tests and test results, as well as sufficient information.
I understand, but didn't the lower courts go beyond that? I mean, representations were made here today that the lower courts actually relied on studies that have since been found discredited and removed. So they were obviously looking at not just what the FDA was looking at in order to make their assessment. So are you asking us to just look at the FDA and not anything else?
So yes, that claim is not even before this court. But with respect to the two claims that are before the court, the 2016 and the 2021, we think the FDA's own statements here are arbitrary. In 2016, what the FDA said was we're going to look at individual studies, and then even though we say they're interrelated at J298, we're going to take all of the protections away at once. That was arbitrary in State Farm. It would be arbitrary here as well.
Thank you.
Thank you, counsel. Rebuttal, General Prelogar.
Thank you. On associational standing, Mr. Chief Justice, you asked where do you cross the line to get to a certainly impending injury. One thing the court has looked at is whether that harm has materialized in the past and how often. Now, it doesn't always guarantee there will be a future injury, but it can be a source of information. And here, what is so telling is that respondents don't have a specific example of any doctor ever having to violate this care in violation of their conscience. Instead, respondents have pointed to generalized assertions in the declarations that never come out and specifically say by one of their identified members, here's the care I provided, here's how it violated my conscience, and here's why conscience protections were unavailable to me. The fact that they don't have a doctor who's willing to submit that kind of sworn declaration in court, I think demonstrates that the past harm hasn't happened, and the reason for that is because it is so speculative and turns on so many links in the chain that would have to occur, and at the end would be backstopped by having the federal conscience protections in play. On organizational standing, my friend has pointed to the fact that they invested time in preparing their citizen petition. She says they voluntarily conducted studies and then generally refers to diversion of resources. If that is enough, then every organization in this country has standing to challenge any federal policy they dislike. Havens Realty cannot possibly mean that. The court should say so and clarify it is at the outer bounds and respondents don't qualify under that standard. On remedy, Justice Gorsuch, Justice Jackson, you pointed out the striking anomaly here of the nationwide nature of this remedy. Justice Jackson, you suggested maybe a more tailored remedy to the parties protecting their conscience protections should have been entered. The problem here is they sued the FDA. FDA has nothing to do with enforcement of the conscience protections. That's all happening far downstream at the hospital level, and the only way to provide a remedy based on this theory of injury, therefore, was to grant this kind of nationwide relief that is so far removed from FDA's regulatory authority that it's ultimately requiring all women everywhere to change the conditions of use of this drug. And I think it's worth stepping back finally and thinking about the profound mismatch between that theory of injury and the remedy that respondents obtained. They have said that they fear that there might be some emergency room doctor somewhere, someday, who might be presented with some woman who is suffering an incredibly rare complication, and that the doctor might have to provide treatment, notwithstanding the conscience protections. We don't think that harm is materialized, but what the court did to guard against that very remote risk is enter sweeping nationwide relief that restricts access to mifepristone for every single woman in this country, and that causes profound harm. It harms the agency, which had the federal courts come in and displace the agency's scientific judgments. It harms the pharmaceutical industry, which is sounding alarm bells in this case and saying that this would destabilize the system for approving and regulating drugs. And it harms women who need access to medication abortion under the conditions that FDA determined were safe and effective. The court should reverse and remand with instructions to dismiss to conclusively end this litigation.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until tomorrow at 10 o'clock.
Hearing arguments as the court weighs whether it's legal to allow the abortion pill mifepristone to be sent by mail without an in-person doctor's visit. The Alliance for Hippocratic Medicine, which opposes abortion rights, is challenging the FDA's relaxed restrictions over the drug. They argue the FDA ignored safety concerns when making that abortion drug easier to obtain, including through mail-order pharmacies. Lawyers for the FDA say the government reviewed extensive data and that the drug is safe. This is the first major abortion case to go before the Supreme Court since Roe v. Wade was overturned 2 years ago. Let's bring in ABC News White House correspondent Mary Alice Parks and ABC News legal contributor Kim Whaley for more. Mary Alice, before the judges can weigh whether these relaxed restrictions for mifepristone are legal, they have to weigh whether the Alliance for Hippocratic Medicine has standing to sue to begin with. And some of the justices seemed skeptical this morning.
Yeah, you're exactly right, Diane. Before they even got to the merits of the relaxed restrictions around this drug, they talked primarily during these oral arguments about whether or not there was reason to even bring this case. Like you said, whether or not the group of anti-abortion medical professionals had injury, could prove that they had standing in this case. And I think you're right that the justice on both sides, those justices we think of as the more conservative justices, those justices we think of as the more liberal justices, across the board all seemed pretty skeptical of this. You know, I was struck by the pretty compelling rebuttal there for the last word that the U.S. government got to make there at the very end of the oral arguments. The U.S. Solicitor General, she kind of summed it up this way. She said that she didn't think that the idea that one doctor in one hypothetical ER room in one hypothetical state should be able to, because they have an issue with this drug, overturn long-standing precedent and safety protocols around this drug for every woman around the country. And I think that that kind of final line from her seemed to, at least from my perspective, listening to our arguments, really land.
Kim, I want to get your take on that because, as Mary Alice said, there's a lot of hypotheticals being posed here. We heard Justice Kagan say, you know, essentially that you have to show that, in her words, that this happened to them in the past, and she literally said, I don't think you have that.
Right. So standing is designed to make sure that federal judges don't wind up making laws and making policy. And so it's designed to require that whoever brings the lawsuit actually has a concrete injury that's unique to them, so a judge can call balls and strikes and make them whole. And essentially, I think all of the female justices, including Coney Barrett, were really drilling down on this idea. Okay, doctors might have a conscientious objection to abortion. Two issues. One, there's already a law that can be invoked in a hospital to say, listen, I don't want to give that care. That separately protects these doctors, and it has nothing to do with FDA. And then second, they went into the affidavit, the facts that supposedly give these doctors standing, and said, you didn't even come up with someone who could say, I was put in a position in a hospital where I had to perform services that bothered my conscience because it involved potential abortion care. And that separate law that protects my conscious objection wasn't protecting me. It's all sort of fluff and hypothetical. And this is, I think, one of the rare cases where the justices really drill down to this question of standing, which is really about constraining the power of the Supreme Court itself.
Kim, we also heard Justice Jackson earlier talk about what she was concerned might be a profound mismatch, in her words, between the claimed injury versus the remedy being sought here. And I found that interesting as this hearing goes on. What we're hearing in terms of injury is all these hypotheticals being thrown up about what could happen in the ER. And yet what's at question is whether this drug could and should be available by mail and through telehealth. How do those two things square, Kim?
Another point on this standing idea, keep the judges in their sandbox. Only let them actually address people's concrete harms that are unique to them. I was injured by the government. Look at my broken arm. And that when you're giving them relief, fix the broken arm. You don't somehow blow up into some massive legislation that somehow bans mifepristone. And so what she's saying is, even if you could come up with this hypothetical doctor who is somehow in, mental trauma by having to perform medical care on someone that might be pregnant, the answer to that is to beef up the protections for conscientious objection in a hospital for doctors. It's not to somehow sweepingly wipe out everybody's access to this drug, which is not just for abortion care. It's also for other kinds of OBGYN situations, people who have miscarried and just need post-miscarriage care, but also for other forms of medical care that don't even have to do with reproductive rights, where doctors and other healthcare professionals might want to prescribe the medication. So it's really the proverbial throw the baby out with the bathwater. That's what she's saying. This is just so overblown. And frankly, I think then the question is, why are we even here? Is this really what this is about, is killing abortion care? And I think that's kind of the elephant in the room that the justices, for the most part, were seizing on very subtly in that lively oral argument today.
Mary Alice, if the court does find that the alliance has standing, the next question is whether the FDA lawfully relaxed these restrictions over mifepristone to allow it to be available through mail order and through telehealth without this in-person doctor's visit. What sticks out to you from what you've heard about that side of the argument so far?
Yeah, the FDA and the federal government argue that 5 million women have used this drug and used it safely since it was first approved in 2000. The real question, like you said, is whether or not those additional sort of ways that they can access the drug that were changed in 2016 make sense, and whether they found they did the proper reporting and proper work to vet those changes, where a woman could be prescribed this drug up to 10 weeks of pregnancy instead of 7, whether they could be prescribed in some cases by a nurse practitioner, and whether it could be distributed by mail, like you said, versus just in person. It was very interesting listening to the Solicitor General there go through kind of the exhaustive scientific research that the FDA did to determine that it would still be safe under those additional sort of requirements and regulations that were relaxed. And she kept coming back to this point, which is the FDA is the experts. If they start to question, if the court starts to question their decision on this one drug with these new regulations, it would open up a floodgate of other potential court cases on other drugs. It was very interesting to listen to the justices really sort of glue in on that idea that this is so rare, that it is almost always left to the scientists, left to the experts at the FDA to make these determinations, and that this would really be a sea change that has the pharmaceutical industry worried, that has doctors worried, and of course patients worried that there would be the court interjecting into that approval process that is normally left specifically to the FDA.
Kim, there also seemed to be a big moment along those lines in terms of the question over these safety issues and whether they were properly evaluated. Earlier in the hearing, when Justice Barrett was asking about ultrasounds, and one of her questions was whether those in-person visits protected against some of the risks involved, because during an in-person visit you would have an ultrasound, and so you would have more information than during a telehealth visit. And the government attorney responded that even back in 2000, when this drug was originally approved with those in-office visits, an ultrasound is not required or a standard operating procedure for those in-office visits. So you'd be getting the same information as you would from that in-office visit as you do now from telehealth. How important was that moment? And what else are you listening for in terms of that line of questioning and answers?
Well, I don't know. I mean, it's hard to say how important that moment is, because as was just explained, the question here isn't so much about what's the best policy, but who gets to decide what's the best policy. And there's a statute that dates back to the 1940s called the Administrative Procedure Act that essentially says that agencies have experts, they have subject matter expertise, and there are many, many dotting Washington, D.C. And if they go through this complex regulatory process where regular people through notice and comment process can weigh in, people, other experts can weigh in, and it gets to the courts to challenge what the agency's done, the courts are supposed to give the agencies the benefit of the doubt. So to hear that kind of Justice Barrett talk about, ultrasounds and things like that, that's very unusual in this kind of a case. And that's the kind of thing you would consider at the lower level where you're actually developing the record, where they're gathering that kind of information from experts. So this is potentially a shift where the Supreme Court becomes maybe the sort of the uber decider when it comes to policy that Congress has determined is really best left to the agency. This, again, it's about, does Congress and agencies that Congress gave the power to, so long as the agencies follow the process of gathering facts, did those legislative and executive branch entities that answer to the voting public, did they get to have deference on this, or do the courts get to fly in and just second guess based on questions they have at oral argument? If that shifts in this case, and there's other cases pending this term on this, if the court decides, you know what, we really get to second guess what agencies do, it's going to create a lot of uncertainty and chaos. And of course, they don't have all the expertise that the thousands and thousands of federal workers across the nation who are hired as civil servants with expertise in certain areas do have. So very, very important case beyond the question even of this particular drug.
All right, Mary Alice Parks, Kim Whaley, thank you both. We'll be right back.
With so much at stake, so much on the line, more Americans turn here than any other newscast. ABC News World News Tonight with David Muir, America's #1 most watched newscast across all of television.
Give it to me. Give it to me. Everything is so fine. Little bit of sunshine. Some more, just a little bit. Breathe more, just a little bit. Smile a little more in a minute. I've been running through the strange life. Pictures on my phone life. Everything is so fine. Little bit of sunshine.
Good morning, America.
Why do so many people start their day here?
From ABC News, this is Start Here.
To be in the know and get a different take on the day's top stories.
A lot of news today, so let's get into it.
Listen now to the Daily News Podcast honored with 4 Edward R. Murrow Awards and see why the New York Times calls it a news podcast worth listening to. Start Here, ABC News. Make it your daily first listen.
Now, that's a part of the story I bet you didn't see coming.
Wherever you get your podcasts, Start Here.
Real Housewives of Beverly Hills star Erica Jane.
Celebrity attorney Tom Girardi.
This story was a nuclear explosion.
Today, several victims will get a chance to finally meet Erica Girardi.
I'm at sort of a loss for what to say.
Did you see the documentary?
The Housewife and the Hustler? I did.
I wanted Erica to say, I'm sorry, face to face.
Erica, why did it take you